litigation dragging on for a couple of years after that. McCombs entered that process very reluctantly, and then proceeded to try to manipulate that EIS process to achieve the outcome that he wanted to see, which was access being granted to their piece of property without having to deal with a lot of the other sort of concerns and issues that the public had raised. The Forest Service doesn't have the staff to do these kinds of big analyses themselves anymore. For better or worse, the agency's been shrinking for about 20 years. So they outsource an analysis like this quite frequently to a private contracting firm. In this case, it was a firm called Tetra Tech. It's a 10,000 employee firm with offices all over the country and in fact all over the world. The Farmington office of Tetra Tech is the sort of the lead office on the EIS. And what we ended up finding out long after the fact was that Mr. McCombs and his project leader, Bob Hans, were essentially blackmailing and bribing the Tetra Tech, the company that was doing this environmental impact statement, withholding payment for each and every chapter of the document, of a 600-page document, until it said the things that they wanted it to say. So rather than this contractor working independently for the Forest Service as they're supposed to provide a, hopefully an independent analysis, what ended up happening was we had a contracting firm working directly for the developer to construct an analysis that that justified granting access without providing really any consideration to all the other associated impacts. So we ended up with a 600-page document that analyzed 250 feet of road and ignored where the road started on the state highway system and ignored where the road went onto the private land. As you can imagine, building 250 feet of road that doesn't go anywhere and doesn't start anywhere doesn't create a whole heck of a lot of impact. And so the Forest Service approved access for actually that road and another separate access point to provide 2 access points to the village in 2006. Colorado Wild sued, basically because...
I have a question.
Yeah.
How do you verify or document that he was actually doing this? Do you guys have that?
Absolutely. And a bunch of that stuff on the Friends of Wolf Creek website.
So this is fact, you're saying?
We argued this to the court. The court granted a preliminary injunction on the basis of these claims. Basically saying...
Claims or facts?
We believe they're facts. The court agreed with us. The developer doesn't agree with them. So I
just wanted to...
Yeah, I wasn't, I was never there, so I can't say for sure what transpired. But based on the documentation that we saw, which included the developer actually writing sections of the EIS, writing sections of Forest Service access policy, writing sections of Mineral County land use code, as well as the developer withholding payment until certain changes were made to the text of the document. We're talking in this case, this was a $4 million contract to write this document. So it wasn't, we're not talking, a significant chunk of money that was being withheld until the document met the developer's expectations, rather than meeting the Forest Service's expectations.
Who paid for that? The developer?
The developer paid for that analysis.
He was required to pay for that, or was
Yeah.
the Forest Service?
Yeah, the developers are required to pay for it, but traditionally, or legally, what's supposed to happen is the developer puts the money in an escrow account, and the contractor reports directly to the Forest Service. And if the contractor meets the Forest Service's expectation, then the contractor gets paid. It is a government contract; it's not a private contract.
No, we don't know why that was done that way.
Well, it wasn't done that way because in this case, Mr. McCombs chose to. Actually, rather than Mr. McCombs directly, Mr. Hans, that was the head man for the project, wasn't very happy with the direction that the EIS was headed, based on the Forest Service direction. So he took it upon himself to try to negotiate with the contractor directly, to try to influence the outcome of the analysis.
This couldn't be due to him maybe saying, I think we have some errors here, you maybe want to look at this again?
No, it was more about like the scope of...
I've dealt with them before too, and had to ask questions and then they ended up agreeing.
Yes. There are certainly lot of factual issues that only the developer can answer the question about. What are you planning to do over here on the piece of property? And those issues aside, we're talking about the scope of the analysis itself. Should the analysis include assessment of the impacts of the village? Or should the analysis include only assessment of the impacts of this 250 feet? So very fundamental, foundational issues to the analysis were the kinds of things that the developer were lobbying actively.
The subject at hand was the easement, right? Was the road.
It was the analysis of the road and associated impacts related to it.
But not the rest of it.
No. So,
One other question, how many feet of road access would he need to hit his private?
depends how it gets there. If he goes through the existing ski area parking lot, it's about 250 feet. If he comes directly off of Highway 160, it's about 1,100 feet, depending on where you where you start and where you finish. Somewhere in that ballpark. Coming directly off of Highway 160 involves kind of bridging a significant ravine there, so there's some cost issues associated with that. So it kind of depends. It also depends on where CDOT will allow you to access the state highway system. As I'm sure you all know, CDOT is a pretty regimented and strict organization. They have their own sort of set of rules and regulations that they make.
And that's
People follow.
10,000 people going through that parking lot.
Yeah, it would be, and what the Forest Service ultimately decided whether it would be better to have a separate access point rather than funnel all those people through the ski area's parking lot. Primarily because CDOT hates the ski area's current intersection with Highway 160 at the base of the S-turn there from a safety perspective, and they didn't like the idea of adding that much more traffic to it. It's also a tricky spot to envision building like a grade separated interchange, which is what would be required for a development of this scale. Talking like Bridge to Nowhere thing over here in Durango, overpasses and off ramps and on ramps and that sort of thing. And so there's certain places on the landscape where that makes more sense, feasibility wise. Other places it just doesn't work.